Any relation?
No relation.
All right, I always put that on the record. All right, the state has filed a motion for continuance. Defense, are you in receipt of the motion?
I am, Your Honor.
All right, do you state, what is your reason for the motion?
The material witness who was a witness to the offense has been unreachable by the state. The state's made different attempts to reach her. We've looked for alternative contact information to reach her, and thus far the state's been unable to reach her, and the state is moving for continuance for more time to find this witness.
All right, defense.
Your Honor, as court knows, my client really needs a speedy trial. The fact is that under 2903, the state needs to establish what due diligence they have gone through to try to find this witness, especially since it's a material witness.
No, I'm aware of the law.
So just putting it on the record, because that's the reason why we have to object to this.
Okay. All right, motion for continuance is denied.
Your Honor, the state has another motion. May I approach?
Yes. All right, the state is tendering a motion to dismiss for missing witness. Any objection? All right, we can go off the record. Mr. Chavez, this case, the state is just asking that it be dismissed or requesting a dismissal without objection from your defense attorney for a missing witness. So what that means is they're not saying they're dismissing it because the actions did not occur. They're saying they are dismissing it because a witness that they need to prove their case is not present. I don't know anything about the facts of this case, but what I do know is you know what brought you here. And if you don't change certain things, you'll be back again. Do you understand?
Yes.
All right, good luck to you. Miss Anne Marie Smith. Hi.
Hi. Do not embarrass me, Jen.
I will not embarrass you. Everyone, I'm going to take yes, I'm going to take a 5-minute break though, because I haven't seen one of my favorite attorneys in forever. We've been on the civil side together all the time. I keep telling her she needs to come back to the criminal side, but she's like, no, I have other out of county things. So just give me 5 minutes, please. Yes, I have it. All right, Mr. Dotson, how are you doing?
All right, and you, ma'am.
Good. We were supposed to be going on a jury trial today. State, are you ready for trial in this case?
Yes, we are, Your Honor.
All right. So your attorney is in trial in another court. She says she's in trial in county court
13, Judge.
13. So of course she can't be in 2 places at the same time. Do you understand? All right. So what we're going to do is we're going to put this on the earliest docket we have for you, so you're not waiting at the jail. All right, Ms. Ferguson, what's the earliest day we can put this back on the docket?
1 second, Judge.
All right, so we're going to put you on the October 3rd docket. That's the earliest we can get you in. You understand? All right, do you have any questions about anything? And you're dressed appropriately for trial?
I have a jacket for a mouse.
All right. And do you have that jacket at the jail?
No, it's at my office.
They're not going to let you bring clothing in. All right, so we'll see you back on October 3rd. All right, and this is an application, Bashan? Court is calling 2023 CR 6161, State of Texas versus Sean Edward Griffin. Can I have parties announced for the record for the state?
Travis Banks of the state of Texas.
Defense?
Samuel Lyles from Mr. Griffin.
And are you Mr. Griffin?
Yes, ma'am.
Counsel, you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Griffin, I'm showing you what's entitled application for deferred adjudication. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, the state moves to proceed on the lesser included terrorist threat, Class B misdemeanor.
Any objections?
No objection, Your Honor.
All right, just a moment. Ms. Ferguson. All right, Mr. Griffin, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand the state is proceeding on the lesser included offense of terroristic threat? That's a Class B misdemeanor. The range of punishment is up to a $2,000 fine and up to 180 days in the Bexar County Jail.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 180 days in the Bexar County Jail and up to a $2,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Absolutely, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Griffin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on a terroristic threat. They are asking for a $0 fine. They're recommending deferred adjudication in the anger management course. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision, there be a TAP evaluation, 60 hours of community service restitution, and no contact with Kevin Chase II. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense of terroristic threat as a Class B misdemeanor, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence?
Yes, Your Honor. The state offers State's Exhibit 1 and its attachments.
Any objections?
No objection.
State, is the complainant aware of this agreement?
The complainant is not aware of this agreement specifically because we've been unable to reach the complainant over the past couple of days, but the complainant did say for us to use our discretion and handle the case as we see fit.
All right, thank you. You may continue to confer.
Yes, sir.
Mr. Griffin, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right, Mr. Griffin, how many children do you have?
I have 5.
All right. And are they all with the person who's in the,
No, it's 4 with her and 1 with
and what are their ages?
15, 13, 9, and 7.
Okay, that's only 4 children.
That's with
Oh, okay. And the other one, how old is that one?
she's 6.
All right. Are you employed?
Yes, ma'am.
What do you do?
I work at IFCO warehouse.
Okay. All right. If you're drug tested today, what are the results going to be
Positive
for?
marijuana.
All right. You're going to have to stop smoking marijuana. It's not allowed while you're on probation. You understand?
Yes, ma'am.
All right. This is what the court will do. The court will sentence you to 1 year deferred adjudication, 60 hours of community service restitution. I'm going to order parenting classes. Once he completes parenting classes, the 60 hours will be deemed satisfied. There's to be regular reporting by Zoom or in person. I'm going to want him tested for levels. Those levels need to start going down. You understand?
Yes, ma'am.
Probation, you can just do 1 field visit to see how everything is. If everything is fine, you can discontinue field visits or continue them as you see fit. Proof of employment within 30 days. No employment as a home healthcare provider with minors. Anger management. Probation, is there anything else? Yeah, we rarely do misdemeanor cases up here, right? All right, is there anything else you need from the court to be successful?
No, ma'am.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Griffin,
Yes, ma'am.
here's the thing. When people have children and they were previously married and that person moves on and they marry someone else, and you don't appreciate the way someone's being disciplined, in this case, the taking away of the phone and the PlayStation, just because the stepfather takes that away as punishment, your answer should have been, let me call the child's mother to see why the PlayStation and phone were taken away. I know about people who are from split households or they divorced. Usually the issues that would come up on the civil side is you have someone who's not the child's parent doing physical discipline. This wasn't even a case of somebody doing physical discipline. This was a case of somebody taking away a phone and taking away a PlayStation. And what you should have done was ask your son, why did they take away the phone? Why did they take away the PlayStation? And whether you think that the taking away of the phone or the PlayStation doesn't fit the actions that your son took, the thing is, don't rush over the house. Time when that's said, the thing is to take some deep breaths, call the mother and say, hey, my son called me. He said you all took away his phone and PlayStation. Why are you taking away the phone and PlayStation? Honestly, I don't understand why children have phones, but that's neither here nor there. We didn't have them growing up because they were not invented. If you wanted to call your parent because of discipline, you had to walk down the block and find a payphone, put your quarter in, or either you had to sneak and find a phone in the house to do it. And there were no phones in bedrooms, at least for children when I was growing up. But so that's the proper thing to do, not to go over there and get upset. You understand?
Yes, ma'am.
You're going to have to learn to co-parent. Now, if somebody's disciplining your child physically, you and her need to talk about that. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you, Judge.
All right, Mr. Williams, your case that you were here scheduled for trial on has been dismissed. All right, so now we have this case that is left. And have you been able to confer with the state on this case?
Yes, Your Honor, we have.
All right, and so where are we?
I made an offer, Your Honor, because previously I don't believe an offer was made except for through the Agasol, so I have made an offer today. I don't believe they're accepting that offer since they haven't came back.
All right.
So,
So as you know, state has just finished with the murder trial and family violence, they're up for trial. So I can bring you back as soon as possible for a trial on your case, but I can tell you it's not going to be today because we have other cases with family violence that are old, that is older than yours. All right, and defense, if you want to file a motion for a bond reduction, you're more than welcome, of course, to do that. And it can be referred to Judge Nahara. Norma,
Yes, ma'am.
what's the soonest we can get this on trial? State, how long do you think this trial will last?
it shouldn't take that long. There's just some outstanding DNA that I'm looking into with the lab right now. And I haven't got an answer back with that yet. So I can't give you a definitive answer, but it shouldn't be that long of a trial.
Okay, so then we need to see about this DNA. And how long do you think the DNA will take?
If it's been done, no time at all.
Okay,
But I would have to disclose that obviously to defense, so they would require those 20 to 30 days, I'm assuming, but I'd have to just determine whether the items that were, again, in our case, have been sent over or not, and I just actually trying to review that currently.
all right, so this is what we'll do. I'll put you down for the earliest trial date that we have, with the caveat that if you still haven't received your DNA, and if DNA is something that the state needs for their case, then we're going to have to continue it. If it's something the state doesn't need for their case in defense, you don't need it, then we can go forward if everybody agrees to go forward. Do you understand, sir? All right, Ms. Ferguson, what's the earliest date?
I think November 7th.
November 7th.
Thank you, Judge.
And Mr. Cabanas, if you want to check in at some point and see if it can be sooner than that with state, the court is always here.
Sure, Judge, just to put on the record.
Oh, well, let's go on the record. All right, court is calling 2020 CR 5285, State of Texas versus Alexander Leonard Williams. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Alfonso Cabañas for Mr. Alexander Williams.
And are you Mr. Williams?
Yes, ma'am.
All right, defense, you wanted to place something on the record?
Yes, Judge, thank you. I wanted to let the court know on the state, I conferred with my client, he's rejecting the plea offer on the pending unlawful possession case.
Mhm.
My client also wanted me to address the court that he is ready and willing to go to trial. And so I wanted the court, or I wanted my client to hear from the court that unfortunately this week is Family Violence Week. So we're not going to go to trial today. We're coming back at the earliest time. And I did confer with my client regarding the DNA issue with the state, let me know about. But other than that, Judge, we're ready. I just wanted my client to hear from the court why we're not going to trial today.
All right, so Mr. Williams, even though it's family violence that are going to trial this week, they have cases that are older than yours, and so that's why your case is being pushed back. You understand?
Yes, ma'am.
All right.
Now,
Yes,
excuse me. Ma'am, I've been remanded without bond since I've been incarcerated. Is there any way I can get a bond in since?
yes. If your attorney, if you all want to call Judge Nahara and see if he's available and see if he'll go forward without a written motion, but do an oral motion, you're more than welcome to do that. But what I will let you know is the reason why there's a remand without bond is on May 3rd, 2023, your bail bondsman filed a motion to surrender surety. So you may want to talk to his bondsman,
Yes, Judge.
and I believe that was Jones Bail Bonds. So,
I've been incarcerated since November of last year now.
okay. No, I understand. And your bondsman, let me just tell you a little bit of the history. So your bondsman got off your bond, then your bondsman asked that your bond be restored, which I signed to have it restored. And that was on April. They were asking that the bond be restored, and that's April 2nd. So I signed it to restore it. And then after that was signed, then in May, they filed another affidavit to surrender surety. And I'm just telling you the reasons why they're saying that they wanted it surrendered was because they couldn't guarantee your appearance from court. Now, mind you, I'm not at the bonds office. I don't know what your contract is with them. I'm not dealing with your contract with them, but your attorney can probably speak with them and see if they want to get back on your bond or not. And counsel, it's Jones
Yes,
Bail
Judge.
Bonds. And they can see. Now, if you want to speak to Ms. Ferguson, you can talk to Ms. Ferguson. She can get in contact with the coordinator for Judge Nahara and see if they're available to do a bond hearing today and do it orally. And usually he's open to doing that if they're not too busy. Okay.
Yes, Judge.
All right. Is there anything else?
Not from defense, Your Honor.
All right. Thank you.
Thank you.
All right. The court is calling 2023 CR 3069, State of Texas versus Edward Alexander Castillo Bringas. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Leo Gonzalez for Edward Castillo Bringas.
All right, we're scheduled for jury trial. The jury is, I've been informed by the clerk. They are in the hallway. Are we ready to proceed?
Yes, Your Honor.
Your Honor, the state is not, and we will tender dismiss.
Any objections to the dismissal?
No, Your Honor.
All right, Mr. Bringas, we're off the record. Mr. Bringas, the state is tendering the motion to dismiss for missing witness. You know what brought you here, and I said this to people many a time. Whatever brought you here, don't come back here, right? Unless you're coming to visit. I do note, and I think the state is aware of the changes that you've made in your life. I know that you've taken many classes. And your defense counsel has made the court aware of the classes that you've taken. I know that you brought people with you from time to time from the military here. So thank you very much. And thank you for your service. All right. So I do remember this case, although I don't have any documents before me on this case.
Yeah, we are,
Jose Marie
Marie Cavazos.
Cavazos. Is this the case where we're waiting on something?
This is the one where my client is in El Paso
Mhm.
and we're trying to get a buckle swap to do an Article 64.
All right. So where are we on that?
Well, the last time we were here, we were going to bench warrant because everything else had failed. We tried to go through the public defender's office in El Paso.
Mhm.
We have tried to appoint investigators. Nobody will touch this because of the chain of custody issues.
Okay. And yes, and I cannot legally
Right.
bench warrant him because I don't really have jurisdiction. He hasn't done anything to warrant a bench warrant.
He doesn't have a case open. He's
Yes.
actually out on parole, and that's part of what our problem is.
Is there,
I had checked with Ms. Ferguson earlier, a couple weeks back, and that was kind of the understanding that I got. I tried to wrap my head around this and try to figure out what tools we do have. The only two things that I think we can maybe do is issue a capias or do a writ of attachment.
all right, let's do this because the writ of attachment is off the table
Okay.
for legal reasons. How far is El Paso from San Antonio? Help me out here with my, if I were in Louisiana, I would tell you how the distance between the parishes. I know I've been here long enough where I would know, but I do not know. Somebody from the audience, how far?
60 miles.
Thank
All
you,
right.
sir.
560 miles.
All right.
So it's a little bit longer to drive from here to Shreveport than from here to El Paso. So does he have transportation to get to San Antonio?
My understanding is that he does not.
All right, Greyhound bus. Is that possible? Do they have, I know they have Greyhound in El Paso. Well, I know you'll stop in every small town.
My trick is this, is that this was a sex offense.
Mhm.
He's currently kind of in a halfway house,
Mhm.
trying to find a place to be able to live. All the places you have has got a bus stop too close, or there's a school too close, or there's something is prohibiting him from being a getting place.
Is there not a professional place?
You would think, honestly.
Do we not have any DNA laboratories that will go to do a buccal swab and come back? I will see
I've
if,
tried LabCorp. I've tried. There is no place in El Paso that will do it. And they flat out tell me, we're not going to do it unless an El Paso judge orders us to. That's the pushback I'm getting. It is ridiculous. And now I've got a PO, a parole officer that I don't know. I've got to coordinate that too to get him to travel.
okay, so request the test, and mind you, I'm just Googling online.
Mhm.
Request the test, order your test. Oh, this is one where they order it and you do it yourself, then send it back in.
Mhm.
But they say they have a laboratory with over 3,600 locations. And you're right, it's LabCorp and
And I've contacted them and I've tried to get them to get on board with this. That was one of the places that we were trying to go through when we were trying to get the public defender to do it.
all right, so let me ask you all this. Are you all available to come back on Friday?
Friday this week, no good.
I
Monday.
probably won't either. I will be in here on Friday or on Monday.
Are you all able to come back on Monday?
No, not on Monday, Judge. We can come back another day next week if that works.
All right. You all decide, confer with each other, decide what day next week you can come back. And I'm going to solve this problem. So this is what I need to solve this problem. One, does anybody have any objections to me solving this problem?
I have no objection, Judge. I need all the help I can get.
Okay,
As long as it's within the parameters of the code, Judge, which I know you're already
Yes.
thinking about those things. So yes, as long as it'll be kosher, which chapter 64,
yes.
that'll be fine.
So this is what I need to solve this problem. I'm going to need to know specifically where he's located in El Paso,
Got that?
some contact numbers there if you have them,
Got that?
and the name and date of birth of your client.
I'm sure I've got that.
All right, so if you all give that to Norma, and on the handwritten item that you give to her, if you're right in there, this is to be done by this date, the date that you all come back, and I'll make sure it's done.
Okay.
This
great.
problem will be solved.
Thank you.
If we all have to do a road trip to El Paso.
I'm flying.
All right.
Southwest.
All right, thank you all.
Thanks, Judge. Appreciate
Sure.
it.
All right, the court is calling 2022 CR 8189, State of Texas versus Leonardo Rosales. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Santos, PSANTES for defense.
And are you Mr. Rosales?
Yes.
All right. We previously sworn in the interpreter, but I'll swear you in again. Could you raise your right hand? Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Cesar Chavez, license number 2203.
All right. So, State, are you ready to proceed with trial?
Your Honor, we are not. We have asked the court to close this case for further investigation. The complainant has given a subsequent child safe, and the allegations in that one, I think, are more worthy of investigation than the current. So I'm looking into the new information.
Defense, any objections to the dismissal?
No, Your Honor, no objections.
All right, the court will grant the state's motion to dismiss. We can go off the record. Mr. Rosales, it appears maybe that the state may be filing additional charges. Do you understand? All right, court is calling 2023 CR 0990, State of Texas versus Dean Villarreal. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Jay Norton and Nico Hood.
All right, this is scheduled for trial today. I have read defense's motion for continuance. Motion for continuance will be denied.
Well, Judge, I mean, Jason, as you know, from the continuance and from the last setting is in Caldwell County, and he's the lead on this case.
Okay.
So he's leaving tomorrow to Philadelphia. He's one of the adjunct professors for St. Mary's. I think you're aware of that as well, Judge.
Yes.
And so he's the coach for them, and so he's not going to be available. He has a letter on file for some time now. And then Monday, obviously, not obviously, but I think he told you he'll be traveling with a colleague and a friend to the Mayo Clinic. He's doing some cancer treatment.
Yes.
And so he's not available, Judge.
Yeah. No, I understand. But with regards to the mock trial that he's having in Pennsylvania.
It's not he's having it, St. Mary's.
Yeah, I know, St. Mary's, and he's supervising or coaching. I have already previously told him that the court is not going to grant him for continuance to coach a mock trial team. This is an old case. I was going to make allowances for the issue with the medical issue, but jury's out in the hallway, so motion for continuance is denied.
Well, Judge, he's not present, so I'm not sure exactly.
He needs to be here, and I told him when he was here before that he was supposed to be here.
There is an additional issue. We tried to, someone from the office tried to view the CAC video last week and was unable to because the state's copy was broken. So as we stand here right now, we have not seen the CAC video as well.
All right, so you all need to watch it.
And for court's knowledge and for court's edification, I have never read Mr. Villarreal's files. I will be completely unprepared to try this case to the detriment of Mr. Villarreal, and he is definitely wishes the court to know that he would like to exert a Sixth Amendment right to the counsel of his choice, which is Jason Goss.
All right, so Mr. Goss needs to be here. Motion for continuance is denied.
Well, just so you know, Judge, he's in Caldwell County, so he won't be here for some time because it's a specially set sentencing, just so you know.
Okay.
Way predates.
All right, thank you.
Okay, Judge, we'll let him know.
All right, thank you.